Hi, everyone. This is Sam Silverman, Managing Partner of EB5AN. Thank you for taking time to join us on today's webinar. Today, we're going to be discussing EB5 source of funds best practices for Indian nationals. And we're going to be covering that from the perspective of Indian investors who are located over in India, as well as Indian investors who are already in the United States on H-1B or other non-immigrant visa categories. During the webinar, if you have questions, please use the chat box, send us a message, and we'll try and cover as many questions as we can at the end. If you'd like a copy of the slides, you can email us at the email address on the screen, info@eb5an.com, and we'll get back to you and share a copy of the slides. Okay, today we're going to chat a little bit about EB5AN. We'll introduce our guest panelists, Anahita Shah, one of the top EB5 immigration attorneys whose practice largely focuses on Indian nationals. We'll talk about different source of funds considerations for Indian nationals. We'll run through a real source of funds case study, and then we'll chat a little bit about one of our current EB5 rural projects, the Twin Lakes, Georgia Rural Loan Project. So quickly about EB5AN, we're a national leading EB5 investment fund manager. We own and operate many regional centers that cover most of the United States. We've worked with thousands of investors from around the world. This is a map showing where some of our investors come from. This is another map showing the areas in the United States where we have active and approved USCIS regional centers. And as I mentioned earlier, I'm Sam Silverman, one of the two managing partners of EB5AN. A little bit more about my background, education experiences there on the left side. We've been in the EB5 investment space for more than 10 years at this point, and have worked on many projects all around the United States. Now I'll turn it over to Anahita Shah, and I'll let her share a little bit about her background and experience. And she's kindly agreed to do today's presentation in 3 languages, so English, Hindi, and Gujarati as well. So for those who don't speak all of those languages or only speak 1 or 2, just please bear with us. She's going to quickly kind of switch from language to language, 1, 2, 3, to make sure that we cover everything in a way that's easily understood by all of our audience members. So with that, Anahita, I'll let you jump in.
Yeah, thanks, Sam. My name's Anahita George. I am the partner of a boutique immigration firm named George and Marzialo out of Seattle. Our practice is 90% EB5. We've done over 500 EB5 applications, and I've been processing EB5 for over a decade now. I'm a licensed attorney in the state of Washington as well as Pennsylvania.
Let's dive into some of the details. So, Anahita, why don't you give us a quick overview on what is source of funds, how does it fit in with an EB5 application, and why is the government, focused on requiring this as part of the application to obtain green cards?
Yeah, it's a great question, Sam. Source of funds is the meat of EB5, along with the project documentation, of course. The government wants to see 2 things. One is that the funds you've accumulated have been legally sourced through either legal employment, legal business, inheritance, which was also legally acquired, and that you've maintained those funds and paid taxes on it. It is very important to prove to the US government that those taxes were paid, whether in India or in the United States. If you don't have your source of funds documentation laid out properly, it results in denial or extensive RFEs or notice of intent to deny, which usually causes significant delay in EB5 applications. So my advice to my clients and investors is put in all the hard work at the beginning of your petition, spend some time, weeks, designing the transaction, and then execute on the investment in the project.
Let's chat just very quickly about the overall application. So source of funds is one piece. What is the other kind of critical piece that needs to go in with an EB5 application?
Yeah, so there are 2 critical pieces. One is the source of funds and one is the project documentation. Source of funds, project documentation packet. The project document packet is not only important for USCIS, but it is extremely important for the investor to educate themselves about what the project is, what the loan term is, or what the equity term is, what the offering are. And my recommendation to my clients is you need to make sure that whatever project you're investing in is freely sharing these documents with you and is allowing you the time to review it and is answering any questions that you have pertaining to these documents. Just to recap, Sam, I think all investors need to understand that if a regional center is not sharing the template of the project documents and is unwilling to answer questions over email, that should be a red flag for any investor.
Got it. Got it. And as part of those documents, how often do you see the financial statements, as part of that set of documents being made available, being shared, and why is that an important aspect of picking a project?
Yeah, that's a great question. I would say maybe 2 projects on the market are willing to share their financial statements. As we all know, these companies are privately operated and they want to guard their financial statements. Actually giving access to the investors to those financials shows transparency, establishes what parent company is funding the project, whether they have the ability to complete the project, and whether they have the ability to repay the investor, not only after they're through with their process, but in case there's some denial in the middle of the process and there's a 5-6 repayment guarantee. Often I've seen the 5-6 repayment guarantees worded as, well, you'll get repaid if the developer has money, or you'll get repaid if the fund has money, or you'll get repaid if we can sell this option. What financial statements do financial statements help the investor to determine whether the developer has the money to cash them out, say within 90 days of a denial, if they're eligible. So I think that transparency really helps the investors make a decision whether the entity backing the project is a shell or it's actually a well-funded entity with assets in it. To summarize, Sam, I think it's extremely important for investors to understand, especially in India. I've heard in smaller circles, there are Indian developers involved or there are smaller projects involved that'll give repayment guarantees to the investor directly. None of that is legally enforceable in a court. If the project refuses to pay you back, you can't go to court and say, hey, this guy promised to pay me, because all EB5 investment is at risk. The way to avoid that issue from happening is to make sure that if a project is sharing the financials, you study the financials in depth and you understand the relationship between that entity, the regional center, and yourself as the investor.
Great. Yep, that's a very good summary. Let's shift gears and talk a little bit about how money gets sourced, right? So obviously any source is permitted as long as you can legally demonstrate where the funds are from and how they've been earned. But yeah, why don't you walk us through, the different kind of major buckets, and obviously these buckets are going to vary for Indian investors coming directly from India versus in the US. So maybe to start, let's talk about these first for investors already in the US, and then talk about these 4 from the context, of many of your clients, I'm sure are applying directly from India, and so they don't have US tax returns.
Yeah, that's a great question. And I would say, Sam, 98% of the time, whether it's funds from India or funds from the US or clients in the US or in India, it's usually a combination of these 4, 90% of the time. Ordinary income is usually clients of mine that are working for Google, Microsoft, Amazon, Oracle, Snowflake, VMware, that have salaries that have accumulated over a period of time that are building up in their bank account. And in that case, our goal is to show that this client's been paying taxes. Here are 5 years of tax returns. Here are the W-2s. Here's the employment confirmation letter. And here are bank statements for 5 to 7 years showing accumulation of wealth over a period of time. What you can't have is you can't have 3 years of bank statements, your balance is 0, suddenly $500,000 show up in your account and you say, well, this is salary. The government's not going to believe that. What they want to see is build up of wealth. They want to see bi-weekly paychecks or monthly paychecks, and eventually that bucket growing larger and larger, and you then investing that money in EB5. Most of the time what we see is clients don't keep cash in their account. They're either investing it in a brokerage account or in crypto, or they're buying real assets with it. When the funds are invested in a brokerage account, the government wants to see a clear line. Here's my bank statement. Here's money coming in through salary. Here are my brokerage account statements. Here's money going from my bank account into my brokerage account. Here are 3 years of brokerage statements that show that I've maintained the funds in the brokerage account. I'm trading with those funds and I'm liquidating at the end of the 3-year mark. In that case, USCIS usually will RFE us. For example, if you're liquidating assets in 2023 and you have then used that money to fund your EB5 investment, we tend to get an RFE 2 to 3 years down the line asking for tax payment proof and tax return filing, because you need to demonstrate that you've paid the taxes on the capital gains that you've accrued. Same with stock options. A lot of my clients in tech field have stock options. They'll liquidate that at the time of filing. We do not have the tax return to show the tax obligation was paid. It is extremely important to either supplement that eventually or have it ready for USCIS when they raise a question. The most common source of funds from India is gift or inheritance from family members. And what is interesting to me, I didn't hit this roadblock until 2016, is my understanding previously was, hey, it's inherited. This inheritance is from 1947 or 1921. There's no way to say that these funds were legally sourced by my great-grandfather. All the government's looking for is an affidavit. The affidavit should attest that these funds used to acquire the land were legally sourced. Even if you have secondhand knowledge, you want to in-depth say, hey, I have heard through my father that my grandfather was a farmer. He used to farm here, and he then purchased this land for X rupees. What is also important is to have documentation, either the purchase docs, which in India wasn't standardized pre-2012. So a lot of the times there are no purchase documents. It is very important that the attorney you're working with let the government know, educate the government that these standardized records in India did not exist pre-2012. If you do not explain that, you end up with a request for evidence that then asks for, give me the purchase contract, give me the copy of the title, give me XYZ, give me bank statements. Extremely important to lay out to the government that the document retention period in India for bank records and tax records is 7 to 10 years. Anything outside of that is going to be unavailable. And in lieu of those unavailable documents, I'm supplementing the record with a sworn affidavit. This is an education process. Keep in mind that the officer that's looking at your documents is not Indian. There's an American person who's going to look at the documents, and your job with your attorney is to educate them about the system in India, educate them about the tax consequences. We recently had a question raised by USCIS about liquidation of property in the United States, and the government wanted to know if the client had over $10,000 in foreign accounts, and if they did, whether they'd filed the F-bar. This is very new. It seems like the government's getting on top of things. They want to make sure that not only are you complying with taxes in the United States, but also in India, in your home country. Anytime an H-1B investor is receiving a gift, it is their obligation to file Form 3520 with the IRS, not only for tax purposes, but eventually when the agency, USCIS, comes back and asks this question. If the gift is coming from a relative in the United States, in the US, the donor is taxed on the gifts given. Extremely important for the donor to file a gift tax return and demonstrate that there was no tax obligation, or demonstrate that the taxes have been paid and the return has been filed. And then finally, moving on to loan from family or friends. This is acceptable after we had Zhang versus USCIS. You can borrow money from private lenders, friends, companies. What is important is that you show the source of funds of that family member, just as if you were sourcing your own income, just as if you're sourcing your ordinary income, just as if you're sourcing your capital gain. It is extremely important to have this conversation with their friends and family prior to taking on any funds from them, that your attorney is going to ask for in-depth documentation of how they acquired the funds. It is also important to have an arm's length transaction between both parties, which means that the loan needs to be at market terms, the rate needs to be at market terms. For example, you can't have a personal loan that spreads out for 30 years. There's no such product on the market. So what you have to do is do some research, see how far a personal loan can extend. If it's 7 years, make sure that you have a 7-year loan. We tend to follow the AFR, which is the federal rate, and then we determine the rate based on the AFR rate. I think historically, clients used to repay loan funds using any funds that were available to them. Now that the processing times are kind of ticking up, we have started to see RFE about source of funds used to repay those funds. So one advice I give my clients is plan in advance, make sure that you're using clean money, money that can be documented for repaying these loans. So all in all, Sam, whatever the corpus is, whatever the base is, whether it's a company, if you have your own business, USCIS wants to go back in time to understand that the source of funds used for the startup capital was legally sourced. So the story needs to start at the beginning. If it's your ordinary income, you need to go back in time, pull out your W-2s, tax returns, bank statements, and show that you were employed and you were indeed getting paid this much money. If it's capital gains, same thing. If you have equities that you've held on for 10 years, you need to show that they were acquired 10 years ago and you've maintained those. And gifts and inheritances, whoever you're inheriting from needs to establish that they legally acquired that asset that they're gifting to you.
Got it. That makes sense. Before we jump into kind of the more specifics of each of these 4 categories, tell us a little bit about, your practice, how you work with clients, what that process looks like, how long it takes typically, what are some of the bottlenecks, walk us through what that looks like, specifically with investors from India that have Indian source of funds.
Yeah, so again, a lot of my H-1B clients have a mixture of source of funds where part of the money comes from the US and part of the money comes from India. The US part is pretty easy. Usually if it's 100% US source, we tend to churn out files in 3 to 5 days. Average file size is 3,000 to 5,000 pages, so it is quite in-depth. For money that's coming from India, a lot of the times there are several bottlenecks. One of the bottleneck is there is a remittance limit of $250,000 from India. It is very important that you plan accordingly. If you're going to spread it out over 2 fiscal years, then you want to make most of your transfers over March and April because the fiscal year in India ends in March. I've noticed that a lot of players, attorneys in the game, don't know that the limit of $250,000 goes away if you're an H-1B client in the United States who has an NRE and NRO account. If you have an NRE and NRO account in India, the limit is $1 million, which solves a lot of your problems. So your relatives can pump in $250,000 in your NRE and NRO account, and you can remit up to $1 million into the United States. So that is one bottleneck that we've learned to clear, is that if they are non-resident Indians, we tend to open NRE and NRO accounts in India. The second thing I've noticed is in sale, property asset sale. In India, usually there's a mix. There's a cash component and there is a taxable component. I get a lot of questions around, hey, can I use that cash component somehow? You cannot. You have to use the price that is listed on the contract. So if the contract says, well, I've paid you $200,000, you've received that $200,000 in your bank account, that is the only money you can use for EB-5 purposes. Any cash transactions that you've done under the table are ineligible for EB-5. The third is for remittance purposes. If you're making remittances from India to the US, the banks in India usually want to know why you're remitting that money abroad. One way to overcome that is if you're remitting to yourself, it's a self-remittance. You're remitting from your Indian account to yourself, self-remittance. Your parents are sending it to you. You can say it's family maintenance under the RBI code. No questions are asked there. However, if the client is in India and they directly want to send the money to the project in the United States, what works is an executed offering document. So if you provide an executed subscription agreement to the bank, most banks in India, Axis, ICICI, Citi, understand what document is, and they understand what you're trying to do. The problem comes when clients try and borrow money against assets in India and then remit it to the US. That is not legal. That is a violation of FEMA rules in India. Although USCIS will not care, the Indian government will care. And if the Indian government alleges wire fraud, that is going to show up on a record in the US, and that is going to bar you from immigration. So you need to be very careful that you're not borrowing from banks in India and then remitting that money abroad for EB-5 purposes. And finally, the consequences of taxes. There are a lot of transactions that are hybrid. There are H-1B clients that are in the US that are getting gifts from their family members in India. There is no tax in India if you're gifting to blood relatives. However, in the US, you're required to file a 3520 declaration, which says, hey, I'm a US person. Keep in mind, all H-1B employees for tax purposes are US persons. They should be taxed just as a US resident or a US citizen is. So if they do not comply with Form 3520 requirements, it is likely that 3 years down the line, the government comes back and asks questions about where's the form. Other thing I've seen is if you do maintain Indian bank records and accounts and the aggregate value of those accounts is over $10,000, there's a good chance that USCIS comes and asks for FBAR compliance documents. The penalty for not complying with FBAR is $10,000 per year plus interest for every year that you've not complied. It is a pretty steep penalty. So for all my clients in India that are currently here on H-1B, my recommendation is to go through all your financial records to make sure that you do not have bank accounts or brokerage accounts in India that exceed $10,000. If you do, you need to file an FBAR because the USCIS is getting extremely smart about it. They want to know about the FinCEN documentation requirements, Form 114. Recently, we had an RFE asking all these questions. Although it wasn't applicable in that transaction, your attorney needs to be tax law savvy in order to answer those questions.
Got it.
Mm-hmm.
On that last point, before you switch to the other languages, why don't you tell us a little bit about your experience in tax and what you were doing previously to, practicing EB-5 immigration first time or, full time, and kind of how that, helps give you some different perspectives that other attorneys without that background, might not be aware of.
Sure, yeah. So prior to immigration law, I was practicing tax law. I'm an undergrad accounting major who's worked at KPMG in their audit department. So I've done a lot of forensic accounting. And for 3 years, I was a tax attorney with Deloitte. And for another 2 years, I was a tax attorney at PwC. So I've hit 3 out of the 4 big 4 accounting firms, worked a total of 5 years, which is why tax and forensic accounting is my specialty. Which helps me understand and educate the clients ahead of time before we see any roadblocks in the future. Sam, to recap, what I have insisted on is that any loans that you borrow from friends or family, you're paying an interest on it. You need to make sure that that friend and family discloses that interest as taxable income, because I've seen instances in which the government has asked for tax records of that person that's lending to you, and they want to see that they're paying taxes. Secondly, even if it's tax-free in India, Indian tax returns have 2 components. One is the acknowledgement, which has all the numbers, finalized numbers, and the second is the worksheet. The worksheet is where you have the itemized layout of, what income you've earned and what percentage it's taxed at. Even if the gift you've received is at 0% tax, you want to make sure that your accountant in India shows that income on computation and shows the 0% tax. So when you go to the embassy in Mumbai for an interview, you can show to the government, here's the registered gift deed, and here is my tax return, which is registered with the Internal Revenue Service, which shows that there's a 0% tax on the gifts that I received from my family members.
Got it. So there's a lot of nuances and things to be aware of, especially when there are loans involved and gifts happening that carry on not just from the initial submission of the petition, but also at the interview stage and also at the final removal of conditions.
Yeah, what we've noticed is even if your 526 is approved, it is rehashed in Mumbai. Those questions are asked again in Mumbai. So I've seen a lot of times attorneys that don't specialize in Indian source of funds will just get the first page of the tax return. That page does nothing. You need to have the worksheets along with this so that USCIS understands where you're generating money from.
Got it. Okay, perfect. All right, so let's shift gears and kind of talk a little bit about some of the real specific aspects. I know we already covered some of this previously, but yeah, tell us kind of what are some of the main things to really be aware of specifically for Indian investors doing source of funds related first to ordinary income here. What are the top 3 or 4 things that you see that you really make sure that clients are covered on in their petition so there aren't any questions later? Yeah,
so again, a lot of nuance comes from experience. These are things I've learned over a decade. Just like the US has a W-2 form, India has what you call Form 16, which is a certificate of tax deduction, which has the name of the employer, name of the employee, your gross wages, and taxes withheld on each of your pay period. It's an extremely important document to attach to your Indian source of funds, especially if you're employed in India. If you attach that along with your tax returns, along with your bank statements, you're in good shape, right? So again, Form 16 is the equivalent of a US W-2. Just like that, Form 1040, the Indian acknowledgement of tax record, along with the computation of income, is the equivalent of our US tax return. So you need to make sure that those documents are in order, and you have to provide last 5 to 7 years of those documents. The second thing is banking records. So in the US, the retention period for any bank records is 7 years. If you were to go to Bank of America and Chase and ask for documents pre-2016, you're not going to get it. In India, that document retention period is 10 years. So you can get documents, bank records as of 2013. You cannot make the argument to the government that, hey, I don't have my 2013 bank statement because it's outside document retention period. Again, under the India anti-money laundering rules, those records should be available. And from what I've seen from USCIS, they have also educated themselves on these retention policies. So if we quote or misquote something, we tend to get a pushback and say, hey, you're not right about this. Third thing is translations are extremely, extremely important. Again, most of India has bank statements in English. All the tax returns are in English. All the Form 16s are in English. So that is not usually a problem with ordinary income. Where we find problem is when you're liquidating an asset, the purchase and sale agreement are in different languages. One question I keep getting asked is, I had the salary, but I spent it. You know, I had the salary for 4 years, but I invested in real estate. Can I just get money from somewhere else and say, this is my salary? You can't, because that money coming from somewhere else is what US government's going to see and say, hey, where's that coming from? If you've invested that money in real estate or in shares, what you want to do is you want to liquidate those pieces so you can claim that the money came from your salary earnings. So it's very important not just to trace the money, but to show that the wealth has been maintained until you've made the investment in EB-5. And again, paying taxes is extremely important. If you're employed, that's very easy. India now has an electronic system. Employers just punch in the data and it shows how much tax you've paid and how much gross income you've made.
Got it. Got it. So there's a lot of things to really be aware of. How many, like over the years, have you ever had any, clients not eventually get approved with your guidance? Like tell us a little bit about your track record, and then also, how many clients have you kind of stepped in and helped who were originally working with another attorney who maybe didn't give the client the right advice or didn't include the right documents? How many of those types of cases have you kind of stepped in on?
So I've done about 550 EB-5s from beginning to end. I have had 0 denials. All my cases have been approved. We put a lot of time into our files. I have seen the big players usually do a great job, but I have seen the smaller players in the field that, because EB-5 is a big ticket item, tend to take on the cases and have no idea what they're doing. India is not like the United States. The systems are really, really different. And if an attorney does not understand that, it really makes an officer angry. I've had cases where I've stepped in where the government has questioned the entire resume of the applicant, and then we have to go back in time and provide, say, Form 16s for each employer, website for each employer, address where they worked, get a confirmation letter. Some of this requirement is really burdensome. I had a recent case where the government wanted me to go and get business registration documents because they did not believe that all these companies that this client was working for were real, because these were small businesses. So it's very, very important to do things right the first time. And it's extremely important for the client to be able to review what was filed before it was filed. Sam, a lot of the times when I get clients from other attorneys, they do not have a copy of what was filed. I have no idea what was said. And that just makes my life harder, because if I don't know what was said and I contradict what was said, that can result in an outright denial, and that can result in severe immigration consequences. So my advice to all the clients is that make sure that before anything is filed, you get to read the source of funds memo and you have a complete electronic copy of what is being filed, and you sign off on that before it's filed. Sam, the last thing I want to raise with ordinary income is a lot of investors in India have their own businesses that they draw ordinary income from. They'll draw salary from their own business. The government still wants to know how you got the money to start the business. They want to see the business's financials. At that point, that business is no longer a third party. It is a related entity. Once it becomes a related entity, you need to explain the source of funds for that entity, right? So ordinary income from your own business, you need to source the business as well as your income.
Got it. Got it. All right, let's shift gears and talk a little bit about capital gains. So I know you've got a lot of clients, who took funds that they earned and put it into a brokerage account, were trading options and crypto and all of that. What are some of the problems, that you see with clients, and how do you kind of make sure that, they don't get tripped up when an adjudicator is reviewing their files and are missing a document or don't have, everything really airtight and linked together?
Yeah, so starting on the US side, I have seen that most of my clients have an average of 5 bank accounts. It is my job as an attorney to go back. If, for example, let's use the example of a Fidelity brokerage account. If they have a Fidelity brokerage account, what we tend to do is we tend to go through all the incoming transactions in the Fidelity brokerage account. If we cannot tie those transactions to one of the 5 bank statements that are the accounts that are owned by the investor or the investor's spouse, we then have to go back and ask the investor, hey, where are you getting this money from? You need to explain, because every penny that's going into your brokerage account will be scrutinized. You also need to show that you've maintained these equities. You cannot have sold the equity, zeroed out your account, and then there's a transfer of equity suddenly in 2020, and you're saying, hey, here are the equities that I sourced from my salary. That is not true. Those equities were transferred from somewhere and they came from somewhere. Same thing applies for stock options. Clients have RSUs that have skyrocketed. And again, it is extremely important that when you are investing in EB5 that you account for taxes. Either if you're not paying now, you pay it sometime in the future, and you make sure you have documentation to substantiate that you've paid those taxes on capital gains. 1099 is the tax schedule that you get in the United States. Outside of United States, most equity transactions have an NSDL statement, which is a national depository in India, which maintains all the equity records. Where you're purchasing, selling, it's a national brokerage. So that brokerage ultimately should be able to give you accounting of all the profits, the taxes, the long-term, short-term capital gains. In India, prior to 2017, long-term capital gains were not taxed. So a lot of the times when I'm submitting Indian files where equities were liquidated prior to 2017, the government comes back and asks for questions, asks like, hey, where's your tax return doesn't show any long-term capital gain. The reason for that is before 2017, India did not have long-term capital gains on some of the equity transactions. Again, this is the attorney's job. Attorney's job is to educate that. And any asset, whether it is equities or it's land, it's extremely important that you document how you purchased that and how you sold that. There's a concept of indexation in India, which does not exist in the United States. So in the US, if you bought a property for 200K and you sold it for 400K, you're paying taxes on 200K. In India, if you bought a property for 200K and are selling it for 400K, the value of that 200K is adjusted for inflation. So it's going to be either worth less, more. It's called indexation. And based on the indexation, your capital gains will vary. Again, that is a concept that needs to be explained to USCIS, because at times when a currency is devalued significantly, like the Indian currency has, your capital gains amount is tiny or it's a loss. Government doesn't understand that. They see your basis and they see your end sale price and they say, hey, you should have paid taxes on 200K. Why haven't you? It is important for your attorney to explain what indexation is. And it is important for you to show that if there are any gains, you've paid taxes on it. And those gains are usually reflected in the worksheet. So you submitting just the first page is not going to educate USCIS on the matter. The last point I'll make is I have a lot of clients from farming communities in India. Farming land, rural land that is sold usually is tax-free in India. Again, this is not something many attorneys know. It is your responsibility, the client and the attorneys, to let the government know in advance. Don't RFE me, because here's support on why this land gain wasn't taxed. Because it's rural, because India is an agrarian economy, here's the Indian tax code, which says that these these profits are not taxable, right? Versus a non-agricultural land where you have to pay income, but the cost is indexed, so your taxes will be lower.
Got it. Got it. Okay, let's talk a little bit about gifts and inheritance. I know this is really important for Indian investors, particularly given that a lot of ancestral land can often be involved in transactions or properties, businesses that are inherited from a long time ago that have been passed down. So yeah, what are for clients where that's an issue, particularly in India, how do you approach that? What are the first questions you're asking, and how do you make sure that the package of documents, if it is going to include significant gifts or inheritance, how do you make sure that you try and avoid questions at the beginning?
Yeah, we when I make a phone call with a client, the first thing they'll say is, "Oh yeah, this property's inherited 60 years ago." They think that takes away the need to document source of funds. It is not true. It causes other issues. The issue, what I tend to ask the client is, when was the property acquired? How is this person related to you? Do you have the title of the property? Was the land register reflecting passage of title from your great-grandfather to your grandfather to you? And where's the sale deed? And where's the transfer of title, right? It's extremely important to run through the entire process. The government is always going to want to know, even if it's a 100-year-old transaction, how your forefathers or your grandma or your great-grandma acquired that property. It can be just in the form of an affidavit giving a brief background on your family members in India. Secondly, if the inheritance has been passed on for 3 or 4 generations, there's a document called 7A. It's the land ledger in India, which will show the passage of these assets from one person to the other to the other. The third thing we tend to get an RFE on is will. If the property was inherited after the person passed away, you need to produce a will. And if there is no will, your attorney needs to, in advance, let the government know that there was no will in place for this, but my client is a class 1 heir. In India, if you're a class 1 heir, you automatically get the wealth if a person dies intestate, right? Dies without a will. How do you prove that you're a class 1 heir? You need to establish the relationship between yourself and your great-grandfather. And the way to do that is you would then produce your birth certificate. If you're the petitioner produces their birth certificate, which has names of both parents. If it was your father's father, your father then produces his birth certificate to show that he was related to his father. And then that land ledger will have the great-grandfather's name, which then will show that, hey, yes, these guys were related and it passed on. What I want to say in short is you cannot make any statements without producing evidence. Your attorney cannot say, my client inherited this land. Okay, where is the exhibit pertaining to that? All of this must be documented. His grandfather passed away, his father passed away, and then he inherited the land. Well, you need to produce the death certificate. You need to produce the will. If there is no will, you need to provide a letter from the attorney in India saying that this was it was an intestate succession, and here are the Indian laws. Or if there was a will, it's been entered into probate, here are the probate documentation. What I see in gifts and inheritance in the United States and in India is clients will say, well, can my friend give me a gift of $200,000? The government, USCIS or IRS, is not going to believe that your friend is gifting you $200,000. So the rule we follow is take gifts from immediate relatives, blood relatives, which could be your parents, your in-laws, your wife, your siblings. Anything outside of that becomes suspect. So limit that pool of gift to immediate family members. Anything outside of that you want to document as a loan where you're repaying. Again, tax obligations are extremely, extremely important. In India, there's no tax. That being said, you still need to explain that to USCIS. In the US, however, if you're in the US and you're getting all this money from abroad, you need to show that these monies were received as gifts, even though there's no gift tax. And again, the donor on their end needs to disclose to your attorney that there's no tax in India as well. So cross-border tax consequences need to be accounted for. Local tax consequences need to be accounted for. And you need to educate the government whether the asset sold is rural, not rural, whether it's an equity, inherited equity, what taxes you need to pay. So to conclude, Sam, inheritances have 2 major issues, especially old inheritances. clients need to make sure that their attorneys document how that asset was acquired by their great-great-grandparents or parents, even if they're not alive anymore. And the second is the tax consequences of that. A lot of the times we get RFEs saying, have you paid taxes in India? And then my advice to attorneys as well as clients is attach a circular which shows that there are no gift taxes from immediate relatives in India. And if there are any tax consequences, it needs to be demonstrated in the computation of income. Very important to work with someone who's done Indian source of funds before, otherwise you're not going to get this nuance or this advice, or you're not going to know what a parallel local documentation is.
Got it. Got it. That makes a lot of sense. All right, let's move on to loans from family and friends and companies. How often do you see this, and is it something that's happening more, more often lately? And what are some of the kind of major issues that clients don't think about that you've had to come in and address? Yeah,
so loans are definitely more and more common since the amount's gone up to 800K. People use it to patch it. Now, loans from, for example, banks like home equity line of credit or asset collateralized loans are easy because then you just have to show the source of funds for the underlying asset. How did you acquire that house and how you're borrowing against it? However, a loan from a personal entity, person, company becomes a little bit more complicated. First thing is, I get a question of, can it be a 0% loan at 30 years? No, it can't. It needs to be at market terms, right? Follow the AFR, make it a 7-year loan. You can make it an interest-only loan. You can have the whole amortization schedule laid out in your loan agreement, which is prepared by your attorney. And at the end of the 7-year, you can have a bubble payment, but it needs to be market terms. Second question I get asked is, well, can I just make it a gift from a friend or a company? You can't. The government's not going to believe that a friend or a company is gifting you money. If you're borrowing money from a company or a friend, you always need to show that other person's source of funds. A lot of times when I step in from another attorney's file, I notice that the attorney has not educated the investor nor the lender about what documents can be asked. So a lot of the times I'll go back to the lender and say, hey, can you provide these documents? And there is hesitation or skepticism. The client will come back and say, hey, well, no one told me I was supposed to provide this and I don't feel comfortable providing that. If that person, the lender, does not provide that document, the case is closed. There's nothing you can do. You have to respond with their documentation, which is why it's very important to have this conversation in advance with the lender to make sure that they're comfortable providing those documents. And the second thing is your attorney can always create a Chinese wall whereby you don't get to see the lender's documents. The attorney is just doing the source of funds on the other side and submitting that to USCIS. So they can create a Chinese wall to make the lender more comfortable. And the third point is, if you're paying interest, which you will be to the lender absolutely needs to disclose that as income, because the government can come back and ask for tax returns that indicate that this tax or interest income has been accounted for. Collateral is, I get the question of, can there be an unsecured loan? Yes, after Zhang, there can be an unsecured loan. However, again, the loan needs to be at market terms. If there's a collateral in place, you need to make sure that you account for how that collateral was acquired. Another question I get asked is, can I deduct the interest rate that I pay on my loan? The answer is no. You cannot deduct because it's a personal loan. Any interest that you pay on it is not deductible. And any foreign documents, again, for USCIS is very, very strict. Any foreign documents need to be submitted with English document on top and the foreign document at the bottom. A lot of the times, loan documents, promissory notes, collateral documents will be in foreign languages. It's extremely important to submit translated documents along with the local language documents for the government to look at. I've had cases where there's a lot of overlap between English and Gujarati or English and Hindi, and the client's like, well, there's only these 6 words that are not translated. You'd be surprised at the RFE you'd get just for those 6 words. So you want to make sure every document is translated.
Tell us what is RFE and why does that matter, and why do you want to really avoid that if possible?
Yeah. So RFE is a request for evidence, which means that the government is not convinced that the story you're telling is true, or they think there are gaps in your story. They're not happy with your explanation. I absolutely loathe RFEs, which is why I put a lot of work in up front. And the reason to loathe is, it's one, you have very limited time. You have 88 days to respond. A lot of the times it's not even possible for the clients to get documents within that time period. Second, once you get an RFE and you respond to that RFE, there's no time limit within which the government needs to get back to you. I have files from 7 other attorneys that are in RFE stage that I responded to that have been pending for 18 months. So you really, really want to avoid that RFE. And the reason that's important for Indian nationals is that RFE can cause retrogression. So 18 months ago, if India hadn't retrogressed, now 18 months from then, India is retrogressed, which means even if you're getting an approval, you're not going to see that green card until your date becomes current. Causes a lot of stress for the attorney, causes a lot of stress for the client. I much rather do all the heavy lifting up front than receive an RFE. Sometimes the RFE is 15, 20 pages long. Sometimes it's 1 page. I've seen RFEs where I've submitted gift affidavits and the government has come back and said, hey, where's the gift affidavit? And then it's just a matter of resubmitting if your attorney has retained a copy of the file. You really want to try your hardest to avoid an RFE. Off late, what we've seen is we've seen the government jumping straight to a notice of intent to deny. For example, if you get an RFE, you respond and the government's not happy. They can come back and send a notice of intent to deny and say, hey, we're not really happy with your answer. You need to provide A, B, and C more. They only give you 33 days to respond to that. If the government skips the RFE stage and sends you a notice of intent to deny and gives you 20 pages to address in 33 days, you better hope your attorney has time to respond to that. And you have the time to run around and get the documents for that as well. So you want to try your hardest to avoid an RFE or notice of intent to deny, which also ties into the reputation of a regional center and a reputation of a project. A lot of the times, even if they have questions about just the project, they'll lump in the source of funds questions and they'll just give you 33 days to respond. Which is why it's extremely important to go with a reputable regional center, a reputable project that has a full set of documents, that has filed a 956F, and eventually, maybe over 2 to 3 years, we'll know what all projects have been approved. But until all the projects exemplar are approved, what you can do is look at the track record, right? So if it's EB5AN, you go back and say, hey, have you had any project-related denials? That saves you from the grief of having to deal with RFEs or notice of intent to deny.
Tell us a little bit about cases where, other attorneys messed something up and you got the call to come in and step in. How many of those cases have you taken on, over the last 10 years? And, were you able to save most of them, all of them? And, what are some of the main kind of problems that you uncovered?
Yeah, so I say I do an average of 3 to 4 cleanup work per month. And I say I have been able to rescue about 98% of them. I usually know in advance what I can't rescue. And it's obvious because when I start taking on the client, I first interview the client. There are 2 situations in which I can't rescue a file. If you've borrowed funds from someone and that person refuses to give their source of funds document, there's nothing I can do to save the file. Second is, if you owe taxes and you never filed that tax return, you can't rescue the file. I could make an argument that, hey, I forgot and I'm now up to date on my taxes and I've filed the taxes, but then it's at the discretion of the government to approve you or not.
What about issues where it's not related to the investor and it's really related to the project? What are some of those problems that you see?
Yeah, off late, especially off late, we've seen a lot of COVID projects that were launched during COVID that collapsed. And we have seen intense RFEs on the project side. And the RFEs want to know a couple of things. One, they want to know, have you been in compliance with the business plan? Have you materially deterred from the business plan? If you have, explained to us the facts and circumstances surrounding it. And a lot of the times the client will say, well, COVID hit, but we're way past COVID now, right? If you haven't made substantial progress towards actually making that entity ongoing and operating, you're going to have trouble. Second thing I've seen is failed financing. So when the file was first filed in, say, 2019 or 2020, the project said, hey, we will acquire the financing eventually. Most of those financing deals failed, or the project never got financing, or the project said, we're going to do 100 EB5 investors, and they got 10, and they didn't have the full capital stack. Fail, right? You don't have the full capital stack to complete the project. Can't overcome that unless you show the government that you've you found the money magically and are gonna finish the project. And the third thing I've seen is going concern issues. So the government has the EIN number of the entity you formed. They tend to run that EIN to check if you filed payroll records, if you've started employment creation. If they see nothing's going on with that entity, they're going to send you questions about the going concern nature of the project. I worked on a project that used biofuels, that was going to manufacture biofuels. And what ended up happening is they promised a very, very high return to the investors. They said, hey, we're going to pay out 7 to 8%. You know, you're going to all do well. And people from India tend to trust other Indians, so people invested. That project never took off because they were going to use grease from restaurants to make biofuel. And in the 2 years, in the year and a half, there was no restaurant waste because of the lockdown. And so that project completely collapsed. And in that collapse, not only did people lose money, it never started, and the government wanted to know if it's a going concern. And as soon as we said, well, it's not a going concern, they did spend some money, they said, well, there's a material change in this entity, and we're going to deny the EB-5. There are times where it's just nothing's been built, and the government says, hey, I looked on Google Earth and I found nothing, you know. So there have been a lot of those cases where the project promised something and didn't deliver, or didn't acquire the right permits, or changed the location of the project, or couldn't get financing. We've seen a host of denials from 2019, 2020 projects because of COVID-related disruptions, right? And to recap, if you're borrowing from friends or companies, make sure your attorney has a conversation with the friend or the company explaining what it entails to lend this money to a third party, to a friend or to a petitioner. They're going to have to go through the intrusive process of source of funds. And if that party is unwilling, you should not be using money from that party at all.
Got it. That makes sense. All right, so let's just hit these kind of couple major things specifically for Indian nationals in your own words. What are some of the kind of main things to be aware of? I know we touched on some of these earlier, but just for each category, what's kind of the one thing, you know, summary piece of advice you'd say?
Yeah, for ordinary income, especially coming from India, always produce tax records, bank records, and Form 16, which is like W-2, and explain to the government that Form 16 is exactly what US W-2 is. As long as you provide those documents, we have not seen any issues with ordinary income. If you're going to invest in fixed deposits or equities and generate capital gains, very, very important to show that the asset was purchased using that ordinary income or legal income. And any capital gains have been completely taxed. Very important for attorneys to explain the indexation method of taxation in India, which means that the money is valued for inflation. So if you invested 200K in something, your basis in that asset isn't 200K, it's whatever the value of that money is today. So it's not as simple as my gain is 200,000, I'm going to pay taxes on that. No, the attorney is going to have to explain what indexation is. In terms of gifts or inheritances, any inheritance, the corpus, the source, will have to be accounted for. If it's 50, 60 years old, an affidavit suffices, but you need to recall details that the officer believes are believable, right? And when it comes to loans from friends and family, first thing you need to do is introduce them to your attorney and make sure that the attorney explains to them what it entails and that they cannot back out of providing these documents. Do not execute a loan. Do not take money from friends and family unless you've already completed the source of funds on their side of the investment. All in all, Sam, to recap, it is very important to design the transaction with the attorney. Once the transaction is designed, we tend to create a checklist. Based on that checklist, then we collect documents. If you're working with an attorney who does not understand Indian documents, you will not know what other documents to provide in lieu of, say, Form 16. If this client does not have a Form 16, what else can he provide? If he does not have Form 16A, what else can be provided? You know, if you don't have a birth certificate, you can provide a PAN card or Aadhaar card, which will have the name of the parents or the spouse. If you don't have a marriage certificate, you can provide an election commission card. All of that comes through practice and comes through dealing with these clients over and over again. And you need to account for deficiencies in documents and pivot by providing other documents that provide the same data.
Got it. Got it. That's really helpful. All right. So I'll ask a couple of specific questions about a couple of these categories. So ordinary income, we talked a lot about, traditional employees. What about self-employed? What are some of the, kind of more important things to be aware of for investors who are going to source either from the US or from India if they're self-employed?
Yeah, that's a great question. I say for self-employed, you want to start at the beginning where the government starts. 3 questions. One is, hey, what was your startup capital and where did you get that money from? If you're in the US, it's unlikely that you're going to have bank records. It's unlikely you're going to have tax returns. What you could probably have is an employment confirmation letter from your old employer that would say, hey, ABC person was making $100,000. What that will do is say, hey, this business startup capital was $25,000. Give them some reason to believe that you had that money at the time to start this business. After that point, they want to substantiate the legitimacy of the business. How do you do that? You provide tax records, audited financials, and you provide bank statements. We, at our firm, tend to use an audit methodology when we are substantiating the income in a business. There's no way for the government to know if every penny deposited in your business is legal or not. So how do you do that? Well, the way I do that with my clients is I'll say, hey, US has last 7 years of records and India has 10. Pull out those records. Let's produce 5 invoices that you have invoiced to your client, and let's tie that to a bank account, a bank statement. So for example, purchase order 3560, I received $80,000. Here is the bank statement that shows receipt of $80,000 on March 15, 2021. You do that 5 times every fiscal year, and you tell the government, hey, the document's voluminous. I'm establishing this. I'm using the audit methodology to show that all the funds in my bank account are legal. If you want more invoices, happy to provide upon request, right? So very important. And the last step is if you're drawing dividends from a company, you want to make sure that it's either on your Schedule K1 and that it's been taxed, or if you're borrowing from the company, that you have the loan agreement in place and then you're paying interest to that company and you're making monthly payments to that company. So it's extremely important for the client to understand whether they're withdrawing dividends from the company or they're withdrawing retained earnings, retained capital. Based on that, the documentation requirement changes, which is why an accounting background with an attorney is extremely helpful. I like the question of, won't a tax return be enough? IRC 61 in the United States says income is income regardless of the source. So even if you have drug money or money from trafficking, all of that income in the United States is taxable, right? Which is why just producing your tax return and saying, hey, look, I have made this money, does not give the government a picture of whether that money was legally sourced. So to summarize, every Indian client ever will say, I have tax returns. Tax returns do not tell the government where you got the money from. All they say is that you've paid taxes on that income. The government wants an in-depth story, a forensic accounting of where your money came from. And if you do not provide that, you will get an RFE, NOID, or a denial.
Got it. So capital gains, we talked a little bit about equities and deposits. Let's talk a little bit about real property. So real property transactions in India and in the US, investors buy a home years ago. Now the home's gone up in value. They want to use part of that appreciation to fund their EB-5. What are things that they need to be aware of and make sure that they work with an immigration attorney before they start executing documents, HELOC, all of that? How does EB-5 kind of fit into those decisions?
Yeah, I have a lot of clients who are either tapping into the home equity line of credit because of the appreciation, or that are selling the property because of the appreciation. The first question I ask them is, how did you buy the property? And you'd be surprised, a lot of the times people brought money from India. And if they did bring money from India, and if there is no accounting for that, you really cannot be selling your property or borrowing against that property. You need to absolutely be able to account for how you paid for that property. If all the money is coming from US income, it's very simple because most clients have used their salary to pay the down payment. And then over the next 7 years, we highlight mortgage payments made every month, month over month to the bank. it's a very intense process, right? However, if you bought the entire property in cash, the government's going to want to know where that entire money came from. When you're selling the property, there's capital gains involved. Now, if you're married, filing your tax returns jointly, and you're selling your primary residence, up to $500,000 is exempt from taxation, right? President Obama passed a law which exempts $500,000 in capital gains. Great. A lot of the clients are looking into selling their primary residence and moving into a new place to capture that gain untaxed. The other option I've seen clients do is they'll do a home equity line of credit, and because they want to raise them funds immediately and then put the property for sale, pay down the loan using the proceeds from the sale. Again, first things first, you need to understand how the property was sourced. If the property is from India, like I said, the RFP I've seen from the government is, well, you bought it for A, you sold it for B, the capital gains is X dollars. Why is the capital gain showing less? Again, like I said, money is adjusted for inflation in India, which means money is worth a lot less, which means you'll either pay more or less taxes, and that needs to be explained to the US government as to why the numbers not neatly tying together. In all, Sam, I think what I want to close with is it's extremely, extremely important to keep the tax consequences in mind. If you have retained an attorney that does not understand tax, my advice is to go hire a tax lawyer. And if you're selling a property overseas and you're in the US on an H-1B visa, India and the US have a double taxation treaty, which means any property of yours that you sold in India, you're going to have to disclose the capital gains in India as well as in the US. The method for calculation is going to differ in both countries. India may say you owe taxes on 100K, US may say you owe taxes on 200K. You're going to have to pay taxes in both countries because eventually the IRS is going to come and ask you questions, and so is the USCIS. They're going to come and ask whether you complied with tax obligations in both countries.
Got it. So being familiar with those rules and how that's going to be reported and, looked at by USCIS is critical.
Yes.
Got it. All right. So gifts and inheritance. We talked a bit about evidence of the inheritance, right? About whether there's a will or if not a will. What's kind of the number one thing, problem that you see with, Indian inheritance, Indian funds or property? Like what's the number one thing that you're just like, oh, this attorney messed this up and now I got to come in here and try to untangle this?
Yeah, I think the biggest problem I see is when the property is inherited intestate, when someone dies without a will. And then the question becomes, is this person a class 1 heir? Is this property still in litigation? Has it been probated? All those questions come in, at which point there's no way to prove if this person is the legal owner of the asset that was sold. So it is extremely important that before the government raises that question, you provide a copy of the Indian law to explain what class 1 heirs are. There's clear documentation of the assets flowing to those class 1 heirs. Most Indian clients don't have a will in place. It is very, very important to provide proof of local intestate succession rules. Explain to the government why you're the only surviving member or your mother and you are the only surviving member. And if your mother has relinquished rights, for example, to that asset, you need to have that document in place, notarized, executed, and filed with the Indian government. So extremely important to show that no other parties in the family have rights over those assets. They've relinquished their rights and that you are a class 1 heir. And if you are not, there was a will through which you've inherited the property. If you do not show that line, you're in trouble. And the second thing I've seen is attorneys don't provide proof of relationship. What do I mean by that? It's something as basic as, I inherited a property from my father. Okay, how do you prove this is my father? You provide a birth certificate. Okay, my father inherited this property from his father. Well, how do I show who my father's father is? Well, his birth certificate. Well, but he didn't have a birth certificate. Well, what else can I provide? I can provide his school leaving certificate. I can provide his Aadhaar card. Both of these documents will have his father's name on it. All right, great. Do you have proof of ID of your grandfather to show that he was a real person? The government can ask for that. If you do not have those documents, it is extremely important to explain why. If you're grandfather passed away 50 years ago, you can say, hey, here's proof that document retention period in India for people that have passed away 17 years. I do not have an idea. I apologize for the inconvenience. However, I'm showing you that I had a relationship with this person this way. So you really have to dumb it down, and every sentence you say needs to have a corresponding exhibit to it.
And so, having gone through that, those types of questions, I'm sure you have, some templates about the A1, class and how that interaction works. And, so you've got a lot of that kind of off the shelf that's proven, that's, been approved by USCIS multiple
Correct.
times. How does
Correct.
that does that factor into how quickly you can get a file completed? Because you don't have to start from scratch. And at this point, you've likely seen, most situations at least one time previously, so you've got something to work from.
Correct. So I have support for, just basic things like what are class 1 errors, what are class 2 errors, what do you do when someone dies intestate? I have laws in India that show that rural property or agricultural property is not taxed. I have laws that show about, how indexation taxation in India works. I have laws that show that, if you're married before 2006, you will not have a marriage certificate. I have laws that shows that if you were born before April 1st, 1970s, birth certificate will not be available. I have laws that show that, prior to 1947, when the British were in India, there was no land recording system. Everything was systemized in 2012. So yeah, usually my job is to add those documents to the file. I will never go ask the clients to prove that to me because, again, I have support for that. I have support for the Reserve Bank of India regulations, which show that banks only need to retain records for 10 years. Support that you can only remit $250K. Support that from an NRE, NRO account, you can remit over $1 million. So that really cuts down the time the client has to go on a goose chase to provide these documents to prove that this is what the local country rules are. To summarize, Sam, very important to understand who acquired the property, your relationship with the acquirer of the property, whether there was a will in place, what the local country rules are, and whether other heirs have waived their rights to these assets if it was intestate succession.
Got it. All right, so let's move on to the last category here. So loans. So what we talked a little bit about this previously, but what are kind of the number 1, number 2 problems that you see clients wanting to do with loans, right? They come to you and say, hey, I've got, XYZ company, friend, relative, whoever is going to loan me the money. And you're like, great. And then, where does that conversation kind of run into, I guess maybe I can't actually do that?
Yeah, so most of the times what clients are trying to do is infuse the company with the money and say, okay, this friend's going to lend me out money. The problem is, again, because you have to go into intense detail about the company or the friend's finances, the government's immediately going to see a big ticket item coming into your account, and that ticket item is then lending money to you. That does not work. It needs to be very systematic. Company's earnings are growing, company has accumulated this much money, and from that money, you're borrowing funds. Second thing I see is clients always ask me if it can be a 0% loan. It can't. It needs to be at market terms. Just because IRS will say nothing is free, so they'll put an implied tax on it, right? So if the tax rate right now, AFR is 4%, and your relative's charging you 0%, IRS is going to imply a 4% gain on your tax return. So either you show a 4% gain on your tax return as income, or you just pay out the 4%, let that person that you're paying to disclose that income and make it a real loan agreement. So that is one problem. The second problem is for cases that I took over in the middle of the transaction, if the attorneys haven't explained that the document, the source of funds is an intense process. A lot of the times there'll be H-1B holders that'll borrow from H-1B holders, and those H-1B holders are scared to disclose their documents, or they're worried that it's going to impact their immigration. None of that happens. It does not impact an H-1B holder's immigration if you're lending to another H-1B friend, as long as the money is legal. But again, because it's such a scary issue that clients are not willing to share their personal documents, especially when they're immigrants. So it's extremely crucial and important to talk to all these lenders in advance to make sure they understand what it takes. My best practice is to talk to the lender personally. I will schedule calls with the lender, explain to them, and if they agree to then cooperate, I will first source their money and then let the investor take funds from that lender. There needs to be a loan agreement in place. Where we differ from other firms is we handhold them for a year. We make sure that every month payments are being made according to the amortization schedule on the loan document, and we make sure that those funds are legally sourced. My firm tends to file addendums every year for loan-based transactions. In those addendums, every year we provide a yearly compliance report where we'll say, okay, Anahita borrowed $500 from this person. Every month she's paying $10 back. Here's evidence of her paying $10 from her salary. Here are bank statements. What that does is it avoids an RFE in the future. So best practice is until the loan is paid up, keep filing an addendum until your EB-5 is approved.
Tell us what is an addendum interfiling? How does that work, and who's doing it? Where's it going? All of that.
Yeah. So addendum interfiling, we tend to use that in two instances. One instance is if you're borrowing money from either a bank or a friend or a company. We tend to then show the source of funds of repayment on a yearly basis, right? And the way we do that is once you file your EB-5, you get a receipt notice. At the bottom of the receipt notice will be the office address or the office that has jurisdiction over the case, where your case is sitting. For EB-5, it's all sitting in DC at the IPO. So once that packet is ready, on an annual basis, I will print the packet out, put a cover letter on the top saying this is my annual compliance report showing that the loan has been repaid using legal funds, and I will put the receipt notice and send it to USCIS. Usually within 4 weeks, we will get a status update on the USCIS's website that'll say, we've received correspondence and we're reviewing it, right? We don't have to do this. I have not seen any firms that do it. The reason we do it is because India keeps going in and out of retrogression, and to avoid any RFEs and future questions, we tend to file these in advance. And the second thing we file is tax compliance. If you've executed the transaction this year, we tend to, the following year, file proof that all tax obligations have been met. The good news is we used to do this all electronic, we used to do this all in paper. Now USCIS is handing out online access codes, which allows us to upload unsolicited evidence to the USCIS account directly. This is extremely great, because it makes our life easier. However, we have not seen it played out yet. We don't know if the government's going to go back to the database and access it or not. So we're doing a twofold approach. We're uploading these documents to uscis.gov, and we're sending physical copies to DC as well. Again, all of this is just to avoid an RFE, to prevent the case from being prolonged more than it needs to. To summarize, Sam, I think what's very important that I want to highlight is loans from Indian banks that are then remitted to the US for EB-5 investment purposes are illegal in India. You're not allowed to do that. I have seen cases where USCIS has approved the transaction. They end up going to Mumbai Embassy. Keep in mind, Mumbai Embassy is the only embassy in India that interviews EB-5 applicants. So they are subject matter experts in Indian law as well as EB-5 regs. They will tend to catch this issue. They will flag the issue and say, hey, you violated local country rules, thereby making your funds illegal and revoking your visa application. So very important to work with an attorney that understands the local rules as well as the US rules.
Got it. All right, that makes sense. So now we're going to shift gears and chat a little bit about a real life situation. I know we've talked a lot about, a lot of hypotheticals. And so we'll talk a little bit about, a real life source of funds case study. And, as you walk us through this, tell us, kind of the importance of really making something very complex as simple and easy to follow and easy to understand for the adjudicator, right? Yeah. You've always got to be thinking, who's the audience for this application, and how do you put it together in a way that's both compelling from a storytelling perspective, but also just logical and just easy to understand, right? Because if the person gets confused, then they're just going to send back a bunch of questions, and you're going to face an undue delay, and may have to find documents that may not be easily accessible. Okay.
We have an EB-5 investor who's an Indian national. keep in mind the EB5 investor cannot borrow funds from a bank in India. So they would be then borrowing funds from a friend in the US. So what do you do in that case? The first step is to provide the identity of the EB5 investor. The second is to show what asset do they own, prove that they actually own that asset, and then go into the source of funds for the acquisition of that asset. So if the asset cost was 1 crore rupees, you need to show how the investor made that 1 crore rupees to then buy this multifamily apartment. If the investor inherited the multifamily apartment from, say, his father, who, for example, was a lawyer, show proof that his father was really a lawyer and had income to buy this multifamily. After that part of the story is over, you've already sourced the asset. Then you move on to the next step and you upraise the multifamily apartment. That multifamily apartment today, for example, upraises for 12 crores, which is more than $800,000. Now that asset can be held as a collateral by your friend that's lending you money. So that friend will then have a loan agreement in place between yourself and him and will record the deed, will record the mortgage on that multifamily apartment. The friend has now made, then you go into the friend's finances to document how the friend made the money. The friend made the money through his digital consulting business. What does that entail? That entails you explaining, show us the business incorporation documents, the EIN, the operating agreement, prove that this person is the 100% owner, give us the business tax return, give us the personal tax returns, give us their bank records, personal as well as business. What the government's going to try and see is that over a period of 5 years, that this person has actually made enough money from the business to lend out the money to his friend. So they will look for a connection between business funds being transferred to personal account, and from personal account, that money accumulating over a period of time to lend to that EB5 investor in India. I get asked a question of, hey, does my friend need to move all that money to India? And then the Indian friend kind of invest that money into the EB5 project? You do not need to do that. We have answers for that. We are able to open US bank accounts for Indians that are residing in India. What that does is it takes away the need of circulating the money around the globe, moving it from US to India, India to US. So the way this transaction would work is the friend would then lend out $800,000 to the EB5 investor. That money would go in the EB5 investor's US bank account, and that from the US bank account, it would then go to the EB5 project that they're investing in. Again, in both cases, it's extremely important to show that the multifamily was legally sourced and that the friend legally sourced the digital consulting business. Always have to provide the IDs of the lender, the borrower, the creditor, whoever is in play. The way I like to write my story is a step-by-step process. When I am working on my source of funds, there are two elements. One is the index of exhibits, and the other is the actual cover letter telling the story. My goal as an attorney, the USCIS officer only has 6 to 8 hours to read through a file. If they can't make sense of that file in 6 to 8 hours, they're going to send out an RFE. My goal as an attorney is to make sure that the officer just reads the index of exhibit in chronological order and doesn't even need to read a cover letter to make sense of the story. So I will start the story as investor was born in India, see Exhibit 1, birth certificate. Investor owns this multifamily asset located in Chembur in Mumbai, see this exhibit. Once that exhibit has been shown, then it's just going from one step to another. So again, the job is to simplify it for the USCIS officer and educate them. What if there is no support? If you're saying something and there's no support for that, you need to explain why there is no support for that sentence. And in lieu of that support, you are providing a sworn affidavit. For example, if this multifamily property was in your family for 3 generations, you're not going to have banking records, you're not going to have tax returns, you're not going to have details about your great-grandfather. You will then provide your sworn affidavit to cover all the gaps within that source of fund. If you do not do that, I promise you the government will come back and send an RFE asking for 1920 bank records. You will laugh at that moment saying, how is that even possible? But it is your job and your attorney's job to then explain why those documents have not been provided, explain the local country rules. Again, very, very important. on a monthly basis, please make those loan repayments. And again, as best practices for attorney on an annual basis, I do recommend filing source of funds of repayment and showing that your friend who has lent you the money is paying taxes on that interest, you're making regular payments on that loan, and that you're current on that loan. Sam, to recap, extremely important that the repayment that is being made is discussed with your attorney in advance. The reason for that is you do not want to introduce new assets. The minute you introduce new assets for repayment, say you're using a property located in other area to repay this loan, your attorney is then going to have to go back and source how that asset was acquired. So best practice is to discuss in advance with your attorney what asset wealth are you going to be using to repay the mortgage. And ideally, you want to keep using that multifamily apartment in Mumbai so the attorney doesn't have to keep resourcing the asset that's paying for that loan.
Got it. That makes a lot of sense. Keep everything self-contained and just easy to follow.
Yeah.
All right, great. All right, so now we're going to shift gears and chat a little bit about EB5 projects. So we've spent a lot of time kind of going through all the different elements of a successful source of funds package, things to avoid, particularly with respect to Indian clients sourcing funds from India. And Indians who are already in the US as well, who may be getting part of their source of funds from friends, family overseas. Before we jump in and kind of talk about one of our current EB5 projects, can you tell us a little bit about what is important from an immigration perspective when you have clients considering different projects, right? What's the talk you have with clients before they even start looking at different projects? What are you really hoping the clients identify in a project that will really increase the likelihood of their success in the process?
Yeah, so I have clients that I classify in two buckets. I have one group of clients that'll come to me and say, hey, I want to maximize my return on investment, which means I want my green card and I want interest or I want upside. And the second bucket will say, I want my green card and I want my capital back. And ideally, it's very easy to work with that second bucket because they're on the right track. If there's a project that is promising extraordinary returns and the market rate is say 0.25%, then comes the need to dig into the project. And as an immigration attorney, I cannot advise my clients as to where to invest, but things that I can do to maximize their success is ask them questions about job creation and the capital stack. So I usually tend to have a 45-minute conversation with my clients about a list of questions that they should be asking of the projects. One of those questions is, has the project started? And are there any jobs in place? The reason to do that is if the jobs are already created in advance, there is no risk of them losing their green card. For example, if the project is building homes and 3 years down the line, the economy collapses. But today that project has enough jobs to substantiate jobs for every investor that is then investing in the project. There is no risk at the 8 to 9 stage. Where I've seen a lot of clients lose their green card, lose their money, is they get to the 8 to 9 stage and the project hasn't started or the project sunk, never created the jobs that are needed. So jobs, jobs, jobs. The first thing I ask my client to focus on is to solve for immigration risk. Look if the project has already created the jobs. The second thing I ask the clients to focus on is if they want to go into an early stage project, I tell them that it's extremely important for them to make sure that the entire capital stack is in place. What do I mean by that? What I mean is the first question to ask the project is, how many EB5 investors do you need to complete the project? If the answer is not 0, you have a problem. The second question to ask is, hey, do you have a loan in place? And by loan, I don't just mean a term sheet. Are you making draws on that loan? Have you used the money from that loan? Extremely important. And the third point, which I think that just as a matter of finance, it's important for clients to understand, is if a project is paying a high interest rate, you need to understand that the way EB5 works is you have the investor, you have the regional center, and you have the developer. The regional center is borrowing money from you, the investor, the EB5 investor, and it is lending to the developer. If the regional center is paying out 4% to the EB5 investor? At what rate is the regional center then lending out the funds to the developer? 4 plus 7, 4 plus 8, 4 plus 10. If you look at bonds, that is junk bond territory. And that is one way for clients to assess risk. If the capital stack is not in place, you have a risk of the project not being completed. If the jobs are not in place, you have the risk of losing green card at the 8 to 9 stage. This is extremely important for my H-1B clients because these clients are jumping off their H-1B, going on to their work permits. They do not want to risk losing a green card because the project didn't take off or the jobs weren't created. So I go through 45 minutes of educating the client, and then based on that, the client comes up with a list of questions to ask the projects and makes the decision as to where they want to invest. Sam, to recap, I think that my only recommendation to my clients is to focus on the track record, is to focus on the job creation requirement, and in this uncertain interest rate environment, to make sure that the entire capital stack is in place, the loan is in place, all the funds from the developer are in place before investing in any project.
Got it, got it. All right, so now we'll shift gears and chat a little bit about one of the current EB5AN rural projects that we have available. It's called Twin Lakes, Georgia. Twin Lakes, Georgia is a single family home project located just outside of Atlanta, Georgia. It's a project with a developer called the Kolter Group. Kolter's been around since 1997, over 25 years. They've developed more than $24 billion of projects, primarily in the Southeast, including 20,000 single-family homes in process and realized over that time period. It follows 14 prior EB5AN Kolter projects. So since 2013, EB5AN and Kolter have successfully completed 14 other EB5 projects. This one, the Twin Lakes, Georgia loan project, being the 15th project with 100% project approval rate from USCIS to date. So investors know that there's a very long track record of USCIS approving the same structure that we're using for this current project over many, many projects over an extended period of time. Let's chat a little bit about concurrent filing. I know you referenced it a little bit earlier about H-1B clients. Tell us a little bit about what is concurrent filing, who does it benefit, who does it not benefit, and how does it kind of fit in with the visa bulletin and India, being current now for rural investors.
Yeah, so the great thing about the Reform and Integrity Act was it allowed concurrent filing prior to the EB5 being adjudicated. Under old law, clients could only apply for adjustment of status after their I-526 was approved. After the Reform and Integrity Act, clients are concurrently able to file for adjustment of status if their date is current or the country of origin is current. So what does that mean? If you look at the US Visa Bulletin today, India is current in the rural, high unemployment, and in the infrastructure category, which means if clients are in the US on H-1B visa, E-2 visa, F-1 visa, L-1 visa, any of these visas, TN visa, these clients then have the ability to apply for adjustment of status with their EB5. So we tend to file their I-526E application with the source of funds and the project documents, along with their I-131 application, which is application for travel permit, 485, which is application for green card, and 765, which is the application for work permit. All of these are filed concurrently. And this is only possible because India is current today, which is why we encourage our clients to file as soon as possible to take advantage of this situation where they can get a work and travel permit. Timelines have been really, really amazing for USCIS standards. We have seen work permits get approved in as little as 60 days up to a maximum of 5 months. So work permits tend to kick in from 60 days to the 5-month mark. What that does, especially for my tech clients in Amazon, Google, Oracle that are burnt out of working these high stress jobs, is it gives them the ability to immediately quit their job and either take a break or work on an EAD or to start their own business. The second thing that happens is usually within 8 to 9 months, these clients get travel permits, which gives them the ability to travel outside the country and come back without having to worry for stamping or without having to wait at the embassy or to be processed anywhere. I've had a bunch of investors on H-1B visa that have continued on the H-1 visa after getting their EAD that have gone to India. The dates for embassy stamping are not available. They have re-entered the country using that travel permit and remained on H-1B visa. So it's a great, great benefit that my clients see. However, it comes with a flip side. This is why it's extremely important for clients to pick the right project because, like I said, if ultimately your EB-5 gets denied because the project didn't do what it was supposed to do, there's a risk to you in that case. And we haven't seen USCIS adjudicate it. It is likely that USCIS comes back and says, all right, you can jump back on H-1B, but it is also highly likely they say, hey, you already lost the H-1B. You were without status. You were basically waiting for adjudication of 485 and 526. In the meantime, you're utilizing this work permit and the project failed, so now you've accrued all this illegal time. So that is another interpretation. So extremely important to protect against that. I tell my H-1B clients to only go for projects that have jobs in place today or that are mid-stage that have all the funding in place. So it is a double-edged sword where the clients have to be more careful about the projects that they invest in, but they also have an immediate benefit of using that work and travel permit to accelerate their earnings, to quit their jobs, to work wherever they want.
So what does that timeline look like? If a client finishes their source of funds package, they're ready to go, then what do they do next? And how do you help them, make this happen?
Yeah, so everything is filed simultaneously. Our track record for H-1B clients is that we finish files within 14 days. So our guarantee is we will turn the file around in 2 weeks. So usually source of funds, adjustment of status, everything is done within 2 weeks. All of it's filed together. Again, work permits are approved in 3 to 6 months. 6 is a high end. Usually we've seen clients get approved in under 4 months. And then the travel permits are approved in 8 to 9 months, which is extremely quick. If you look at H4 EADs right now, in order to get H4 EAD, the minimum wait time is 6 to 8 months. So EB-5 is prioritized and is getting EADs a lot faster than any other category. To recap, Sam, I think that we don't know how long India remains current or China remains current. We encourage our clients to file for adjustment of status while India is current. And the benefit of that is the work permit is valid for 2 years. After that 2-year mark, even if India retrogresses, you can keep renewing that work permit until you get that conditional green card, which is a huge added benefit. The downside to it is the clients need to be extremely, extremely cautious in the project that they pick. They want to make sure that they're not picking a project that hasn't started construction yet. I'm not saying that the project's going to fail. It's just to protect them from the failure of project launching or not getting the requisite permits or not getting the requisite financing. It is always better for H-1B clients to go into a mid-stage project that has already put in the jobs in place and that they know that there's no risk of default or the project not continuing.
Got it. Got it. That makes a lot of sense. So circling back to the project. So the Twin Lakes, Georgia project, again, it's a large single-family home community with amenities. It's located just outside of Atlanta, Georgia. It qualifies as rural, which means that investors in the project are given priority processing of their I-526E green card application. And it also means they have access to a 20% visa set aside. Anahita, do you want to tell us a little bit about what do we know? What is priority processing? How does that likely differ from some of the other categories? And why is the set aside really important for Indian-born investors?
Yeah, so I would say that let's talk about priority processing first. So under the Reform and Integrity Act, rural projects have priority processing. There's 3 kinds of processing. There's expedited processing, which is given to humanitarian clients in humanitarian need or emergencies or because of USCIS error. That is extremely fast processing. Even that takes a year though, at least. The second is priority processing, which is what the rural projects have. And the third is regular processing, which is all the other unreserved category, the high unemployment TEA, and the infrastructure category. So industry estimates that rural projects, investors in rural projects are going to get processed faster than other EB5 lines because of the way the regulations were written. The issue we have is that we have no data yet to see how long that is. Again, the industry expects that approval to be around 24 months, but it's kind of in a wait and watch mode. To me, the bigger benefit of rural is that 20% set aside, and that is extremely important to H-1B holders with kids. Why is that important? For example, say you get your EB5 adjudicated in 3.5 years in rural, and once it's adjudicated, India is not current. Well, India is not current, but 20% of the visas, because you invested in rural, have been set aside for the rural category. Since this line is very new, there are not a lot of people ahead of you in this line. So the sooner you file, the better it is. The more people will line up behind you, the better your odds of capitalizing on that 20% set aside are, right? So that really helps in protecting your kids from aging out. That really helps in fighting retrogression. If there is retrogression, you still have that 20% set aside for rural that you can get allocated in spite of India being retrogressed.
What is retrogression, and why does that matter?
Yeah, retrogression means EB5, all American visas, immigrant visas, have a quota. EB5 has a quota. Once that quota per fiscal year gets used up, the government moves the dates back. What that means is, currently, if you looked at the unreserved category, India is in April 2017. What that means is most EB5 visas for that year, this fiscal year, have been used up. Government's not going to print any more green cards unless the fiscal year changes, which is on October 1st. On October 1st, the government will resume printing green cards again until they use up the quota for the next fiscal year. So if you're in a rural category and if the quota for that fiscal year is over, but that 20% has not been used up, you will get allocated that 20%. What that does is, once your EB5 is approved, if a green card is not available, the government won't be able to print a green card for you. However, once the EB5 is approved and a green card is available, but under the 20% quota, you can still get your green card printed. What that does is it approves your conditional green card faster, rather than waiting for India to become current in the regular line. So to summarize, Sam, for Indian investors, we've seen a lot of rush in the rural TEA projects because of the priority processing and because of the 20% set aside. And there's also this faith that because this line is very new, it has just opened, most projects on the market are high unemployment TEA. People are making assumptions that that's why most investors have ended up in high unemployment TEA projects. Rural is a better place to go by extrapolating that logic. And so people are going into rural for that 20% set aside to protect their kids from age out and to benefit from priority processing.
Great. That makes a lot of sense. One of the things that we really like about the Twin Lakes, Georgia project is that it's a proven business model, right? The entire community is going to have about 1,300 single family homes. And as of July 1st, we know that over 520 homes have already been sold, and over 370 homes have actually been constructed, built, and residents have actually moved in and are living in the community. The clubhouse is done, the pickleball facility, all the amenities are pretty much completed and open and in place. And so the project is a going concern. It's already profitable. It's created almost 2,000 EB5 eligible jobs already. So a lot of that risk of, are they going to get the financing? Are people actually going to buy the product that this project is going to sell? Is it going to happen? Is it going to be profitable? A lot of those questions have already been addressed. And clients coming into a project like this that really started construction 4 years ago are really getting the benefit of having a lot of that execution and feasibility risk having been eliminated, right? As I'm sure every immigration will tell you, an EB5 investment has to be at risk there must be the potential for gain or loss in order for an EB5 investment to qualify for the green card. However, the amount of risk that you need to take on when you select a project, it can be very low, right? There just has to be some element of risk there. In this case, this project, 520 homes have already been sold, but there's still more than 700 homes that have not yet been sold, right? So how quickly and when those homes are going to be sold and built, that's a projection, right? So there is that element of risk and lack of clarity, which allows us to satisfy that at-risk requirement, compared with a project where all the financing is not in place, the project is dependent on future rents, no one's rented yet, they have to build the hotel, build the apartment building, and then they're hoping there's going to be a refinancing event at some point in the future. Those types of projects tend to be a lot more speculative, where there's a lot more execution and financing risk that the client is taking on. Now, those projects will also qualify and satisfy that risk requirement for EB5, but the risk level is a lot higher, and it's certainly far more than the level that's required for the investment to qualify as being at risk. So one of the other things that we really like about this Twin Lakes project is it's an age-restricted 55 and up retirement community. The retirement community brand is called Cresswind, and it's a proven brand. This location, Cresswind Twin Lakes, is one of 13 Cresswind communities across the Southeast. So not only is this particular location proven and successful, but it's one of, effectively a franchise of a successful retirement community platform with amenities, single family home models that's proven in multiple locations around the Southeast, right? So there's a very strong track record that this type of business works not only in this location, but also across many other similar locations in the same area of the United States. Now, one of the other things that we talked about earlier was 5260 approval guarantees, safety of funds. How do we make sure that not only is the EB5 immigration process successful for investors, being that there's enough job creation for them to receive the permanent green card and get 829 approval, but we're also very concerned with capital safety, right? Making sure the investors' funds, that $800,000 that's being invested, is safe and that it's going to be repaid in a timely manner, right? And so one of the ways that we accomplish that with this Twin Lakes project is we have a loan repayment guarantee from one of Kolter's parent holding companies. So one of Kolter's entities with significant assets, almost $400 million in assets, provides a repayment guarantee that secures the loan. And that entity, not only does it have significant assets, but it also has significant net equity. And it's basically a diversified entity that really materially increases the likelihood that the investors are going to get timely repayment of their funds. In many EB5 projects where the investment is structured as a loan, the security of that loan will just be limited to the project itself. And so if something happens with a project, let's say it's a hotel project or an apartment project, if for whatever reason that apartment building at that location or that hotel at that one address is not as successful as people thought, then oftentimes the investors could lose money, all or part of the funds that they've invested in, because the repayment is only tied to that one building producing enough cash flow and a refinancing event in the future. We want diversification, right? Just like when you invest in the stock market, it's usually not a good idea to bet your entire net worth on a single stock, right? The same strategy applies here. We want diversification for that investment. And so even though the funds are going into the Twin Lakes project to satisfy the at-risk requirement for USCIS for the EB5 program, the security of the investment, the obligation to repay those funds on time, is tied to a much larger entity that's completely separate from the project, and it has a large balance sheet, right? It owns more than 35 different projects that are all spread out. And so that repayment is diversified, and that means it's a lot safer than having the repayment tied to just a single asset, right? So you tie, that kind of diversification combined with the fact that the Kolter Group is one of the largest developers in the southeastern United States. They've successfully borrowed and repaid billions of dollars of loans over the last almost 30 years. They've never not repaid a single loan, right? So you tie that track record and kind of fiscal responsibility combined with the fact that this project's repayment guarantee is with a diversified parent holding company with significant assets. We think that those two factors combined make us one of the safest rural EB5 loan projects available on the market today.
Sam, I get a question from my clients about EB5 loan repayment guarantee. I believe they talk to projects around all over the United States, and they will often come to me and say, hey, how can EB5AN give us a loan repayment guarantee if our funds need to be at risk? Can you address that, please?
Sure. So we actually have a blog post in process on that exact question, because it's one that is quite common. And a lot of our competitors will use that safety feature as a way to confuse clients, unfortunately. And so let me give you kind of a little bit of clarity on how that's structured. So we've been using the concept of an EB5 loan repayment guarantee since 2014. We've used it on more than 10 prior EB5 projects with Kolter, and we've received 100% USCIS approval on those projects. So there's no question whatsoever that a repayment guarantee is allowed. And it is obviously allowed with Kolter because we've gotten many of those approvals to date. Now, why is that the case? Why is it allowed when the regulations, the EB5 program rules, state that funds must be at risk, right? It goes back to that same idea that there's many different levels of what the government considers at risk, right? The way the government defines at risk is the potential for gain and the potential for loss, no matter how large or how small, right? It just has to be there, right? Potential for gain, potential for loss, right? Now, Kolter is a very large company. They've been doing business almost 30 years. The same situation applies for any large, successful, going concern business, right? So if I'm an investor and I decided I would want to make a loan to Microsoft, right? Microsoft's a huge company. They've got a big track record. They have a large balance sheet. They've been in business a long time. But Microsoft is a for-profit business. It's a going concern entity. And like any business, it's possible that that business could fail, right? Maybe 2 or 3 years from now, they overinvest in AI and all of a sudden they run out of cash and they have to declare bankruptcy, right? Very unlikely, but it's theoretically possible, right? Fortune 500 companies have failed over the last 30 years. It's not impossible, right? So that possibility that you've made, a loan, or that a loan has been made to you from that type of entity that has a big track record, even though it's very unlikely, the fact that it's still possible, that still satisfies the at-risk requirement for USCIS, right? So there's no way to reduce the investment risk down to zero, because then it would be considered not at risk, right? But what you can do is you can lower that risk to a very low level. And we believe that having this type of repayment guarantee from a separate diversified company with a track record of repayment over a very long period of time and significant assets and net equity, we think that's the best way to lower that risk as low as we can without touching the zero risk level and still qualify for the green card. The other two things that we have on this slide that I'll quickly mention is this same entity that's providing the loan repayment guarantee is also providing an I-5-60 approval refund guarantee, which basically means that if an investor's application is denied for any reason, they're going to be promptly refunded, right? That's beneficial, especially if you hire an immigration attorney who doesn't do a good job, because then you'd be able to get your money back early and you wouldn't be waiting until the end of the investment, right? So these are safety features that we've built in to give clients peace of mind. But the reality is that as long as you hire a really experienced immigration attorney and follow their advice, like Anahita, you won't have any issues getting approved. The last item is the job creation guarantee. So as Anahita mentioned, in order to successfully complete the entire EB-5 process, you need to create 10 jobs, and you have to be able to show how those jobs were created. This project has a job creation guarantee, and more importantly, it's already created almost 2,000 EB-5 eligible jobs. So for our clients coming in today, when they join, they know that we've already created those jobs that are sitting there in a job bank and available, to be assigned to them. So those different safety features really, set the Twin Lakes Rural EB-5 project apart from many of the other both rural and non-rural projects that are out there. Unfortunately, many of the rural projects that investors will see in the market are projects that are dependent on EB-5 to happen, and they really wouldn't be happening perhaps if EB-5 wasn't available. This project is pretty much the opposite. It was started late in 2019, years and years before there was any preference for rural projects, which only came about in 2022. And it's successful, it's proven, it doesn't need EB-5 capital. EB-5 investment is a nice to have for the project. And so it basically is just a really solid development project that happens to qualify for the rural designation, right? And that's really what you want to be looking for, is you want a project that doesn't need EB-5, not dependent on it. It has other sources of capital. It's a proven economic model. You can see revenue being generated. You can see profit being realized. And that really helps you eliminate a lot of the risk that you'd otherwise be facing if you're building a project that's like a hotel or an apartment building where, maybe the project was planned out 3 or 4 years ago, prices have gone up, maybe rents have changed, people no longer want to live in that area. And when eventually the project gets built, all of a sudden interest rates are much higher, debt service is greater, and now the project can only generate half of the rent that it was targeting. And because the debt service and interest rates are higher, now all of a sudden the project is facing bankruptcy, right? Why take that kind of chance years in the future on an unknown refinancing event when you can go into a project that's already proven, that it is able to generate a profit in the current economic climate. And obviously, not just at this one location, but across many locations around the southeastern United States. One of the other things I'll just touch on quickly here is Kolter. They're the #1 developer in the active adult single-family home market. So they've got more market share in this market than some of the largest publicly traded home builders in the United States. So they've found a very specific niche, active adult, under the Cresswind brand, and they're just executing and doing extremely well, even compared to some of the largest and oldest home building companies like Lennar and Pulte Group. They're doing even better than those companies. And lastly, don't don't just take my word for it. We've conducted 8 so far as of July 4th, 8 different EB5 investor interviews from investors, many of whom are Indian H-1B and India-based EB5 investors on their. So it's really important when you're making an investment to get other perspectives, right? Some investors have experience with real estate, some of them are attorneys, some of them are not. Some of them are software engineers, some of them are data scientists, and they may not be experts in understanding how a real estate development works, how it gets financed, what are the risks involved. And so it can be really beneficial to hear perspectives from other investors, who may have more relevant experience as to why they decided to select one project over another. One of our investors, actually Ken here, who worked with Anahita, did EB5 investments for 6 of his family members in the Twin Lakes project. So he wrote a check for $4.8 million and gave $800,000 to 6 relatives, each of whom invested in our Twin Lakes project. So it's, there's no exact right project for every investor, but you just got to really do the research and think about, what's most important to me. Do I really want to focus on capital preservation, making sure I get the $800,000 back in a timely manner, and make sure the green card process goes smoothly? Or, do I really want to just try to chase a higher return and, getting the green card successfully and, potentially losing, some of the principal capital is secondary, right? You just really got to decide why am I making this investment and what do I really want to prioritize, right? There's no free lunch, right? Just like any other investment, if you're going to be, targeting a higher return, you're going to be absorbing and accepting higher risk, right? So, that's really a key aspect when it comes to project selection. And with that, I guess, Anahita, I know you've represented a number of these clients. What are some of the most important things that your clients have kind of conveyed to you of why they decided to go with the Twin Lakes project?
Yeah, I think the number one reason is because most of these clients are H-1B holders, has been the job creation aspect. The fact that this is not an early stage project, this is a mid-stage project. All of these guys already are going to get the jobs that are in place. They're going to be allocated the jobs. The second thing I've heard is that they're very comfortable with the Atlanta metropolitan area, unlike some of the areas like where I live in, which is in Seattle or San Francisco, has experienced exponential growth and are kind of coming down now. Atlanta is experiencing quite a bit of boom. The third thing is definitely Kolter. All these people recognize the Kolter brand. And I have a client who went in and looked at bankruptcy records to see if Kolter had filed any bankruptcies in the last 20 years or how they did in the 2008 financial crisis. And then just the home sale velocity. I mean, I think even in a high interest rate environment, clients have said that they feel comfortable with an aging US population investing in homes that are age restricted.
Got it. That makes sense. All right, so before we conclude, and all just real quick note, all of these testimonials, they're each about an hour long, are all available on our website. If you go to eb5visainvestments.com/testimonial, you can see the full videos and transcripts for each of these interviews. I guess to kind of wrap up, can you walk us through the process for engaging you to help with source of funds, and also, just kind of tell us, why should an Indian-born investor, whether they're in India or whether they're in the U.S., why should they go with you, right? There's thousands of attorneys, maybe not all of them have a lot of EB5 experience, but why should that profile of client, why are you kind of best situated with the right experience to help them get through the process and not have any issues.
Yeah, for sure. So in terms of getting in touch with me, of course, the best way to reach me is through WhatsApp or email. Those details are on this slide. I would say that to start the process, I tend to provide a free 45-minute consultation to my client, to potential clients, before charging any money, just to understand what their source is, to kind of tell them what roadblocks they're going to see, and to understand where they are in the project selection process, if they've made a decision, or they're in the process of making decisions. Once that initial conversation is done, the client understands what roadblocks they need to overcome. And if they think they can overcome those roadblocks, then they choose to retain me. Once they retain me, we start working in coordination with each other to kind of resolve issues or to start documenting the source of funds. Like I said, I have about a decade of history doing EB-5, experience doing EB-5. I spent the first 18 years of my life in India. I can read documents in Hindi, I can read documents in Punjabi and in Gujarati, so all three languages as well as English. What helps me a lot is that 18 years spent in India, educated in India up until college, I understand the Indian system, the tax laws. I was an accounting major back in India as well. And having the forensic accounting background overlaid on it, there is not a single source of fund from India or from the US or a combination of both that I have not seen. We are a boutique firm. We tend to provide one-on-one attention to the clients. So clients have reached out to me at 2 a.m., 3 a.m., and I've been able to answer that question. What is extremely important for us as attorneys is to provide that level of customer satisfaction, especially when clients are located in Asia. What we tend to do is we will have a bunch of attorneys, including me, that will work night hours in order to coordinate. Otherwise, you lose a lot of time in just emailing back and forth. If I send an email this morning and I go to bed, or at night and I go to bed, the client sees it at night, they have any questions, they have to wait until I wake up. So based on the customer's profile or the client's profile, we decide what times we're going to work, and we customize that entire experience. On top of that, there is not an RFE I haven't seen. There is not a case I've not resolved. I have done about 220 India EB-5 applications with 100% approval rating. And so if there's any roadblock you're going to hit, I'm going to see it before we even file the application. Or if there's any roadblock that I see, I probably have an answer for it, or I just need to sit and brainstorm with the client. So we're not going to go back and reinvent the wheel. None of this is new to us. Everything is just second nature and habit. And I think we have one of the fastest processing times in the industry when it comes to processing EB-5 files. Like I said, for my H-1B clients, we process files in under 2 weeks. And for my Indian clients is about 4 weeks. I get a lot of clients from big law firms with big reputation coming to me that have been sitting on source of funds for 6 to 8 months. I've also seen a lot of practices where these attorneys in the US will outsource their work to accountants in India. And the accountants in India only understand the Indian side of things. They do not understand the American side of things. Here, you work directly with an attorney that understands the Indian laws, the Indian regulations, and understands what questions are going to be asked at the embassy in India and how to answer those questions. So we are boutique. We are a mid-sized firm. We specialize in EB-5, and there is not an Indian scenario we haven't seen after doing 220 files from India with 100% approval rating.
Got it. And tell us a little bit about, your presence in India. I know you travel there regularly, and you still have, significant family there. If clients are in India and they want to meet you, or how do you kind of provide that, personal level of service with a client base, that's halfway around the world?
Yeah. So, I travel to India 3 times a year. Again, I have family in Gujarat and Ahmedabad, but not just that, I try and meet clients in person, but on top of that, like I said, I have clients that have approved EB-5s or US passports based on EB-5s that are all spread out throughout the country that tend to then guide my future clients. So I'm one of the few attorneys that are able to provide 5 to 10 references in the city that the client is located, that gives the client a lot of comfort, you know, that they're not the only one, or there are these 10 other people in their vicinity that have dealt with this attorney that has taken them from start to finish. So not only do we travel to India and meet the clients, but there are also enough people spread out across India, clients of mine, that already have their conditional green card, permanent green card, or US passports, that are then willing to guide the new set of clients through how they overcome certain issues, or how their experience was with me, and how they went through their project selection experience.
Got it. Talk to us a little bit about just independence and why, you know, it's critical to have an attorney who really has, you know, your best interests at heart, and how that, you know, varies across, you know, some of the other attorneys and some of the other projects.
Yeah, that's a great question. The first tip that I give my clients when they call me is, if they don't ask me if I work for EB5AN or have any affiliation with EB5AN or any other regional center, is I tell them, hey, your first question should be, have you ever represented a regional center? Or have you done the project docs for the regional center? Or are you in any way in bed with the regional center where any conflict of interest would result in you withdrawing your representation in this case? And that is a question I believe every EB5 investor should be asking of the attorney as well as the project. I think a lot of regional centers that I work with will say, hey, here's an introduction to a specialist. That being said, we don't care who you work with. But there are a certain few that I know that have attorneys that have done their project docs that are also recommending the same attorney to the EB5 investor. And if you try and bring an outside attorney in to do the source of funds, there's going to be pushback. It's extremely important for the client to quiz the attorney to make sure that the attorney is only on the investor side of EB5, not on the regional side of EB5. Clients do not realize that retainers have legal language that will absolve these attorneys from conflict of interest. It is extremely important for clients to read the retainers to make sure that they're not working with a conflicted attorney. If you're working with an attorney that has represented the regional center as well as the investor, the next question is, whose interest is the attorney looking out for? Is it your interest as the investor, or is it the regional center's interest? Because at this point, the regional center has paid this attorney to do the docs, and the investor is paying this attorney to do source of funds. So who does the attorney's loyalty lie with? It is extremely important to ask that question. And I always say, even if Sam's recommending me as an India expert, I know at least with EB5AN, they tend to recommend multiple attorneys, and you're free to work with whoever you want to, or anyone outside of that as well. You need to have that with any regional center you're approaching. You need to make sure that the attorney isn't paid on both sides and isn't in bed with a certain regional center, and is going to give you the honest opinion on your source of funds, as well as on the immigration side risk on the project itself.
And just kind of as a different angle on that same topic, you know, for those who aren't regularly hiring attorneys in the US, tell us a little bit about, you know, just fiduciary duty, client, you know, confidentiality, attorney-client privilege, you know, describe that, you know, trust relationship, and why, you know, it's almost like a, you know, like a mini marriage, you know, for an extended period of time with the attorney that you're going to pick, and, you know, how that kind of factors into who you should be picking.
Yeah, so as Sam said, EB5 is a long process. It is not short. It starts the day you make that first phone call to your attorney, to the day you apply for removal of conditions, to the day you get the removal of conditions lifted, and then you become a US citizen. You're talking about a 7 to 10 year marriage with the attorney. You better like the attorney you're working with, you better feel heard, and you better feel respected. What I've heard in the industry, and I think attorneys have a bad reputation about this overall, is once the retainer is signed and the funds are paid, attorneys are slow to respond. They will not respond quickly enough. The way we design our retainer is we divide our payments in half, and that is particularly done to give the attorneys and the clients the peace of mind that, you know, the attorney is going to continue working because they have that other half to collect. We also design our transaction in phases so that we're not charging all the money up front for your removal of condition service that is going to be rendered 7 years down the line, and you're now married to us. At every stage, it is your choice whether to continue with us or not, or to go to another attorney. I think fiduciary duty is a concept that a lot of clients abroad do not understand, because lawyers are not a common feature for these kind of transactions. So in the United States, under the bar rules, attorneys are allowed to represent one side of the transaction. So if I'm invested and I'm representing an EB5 investor, I'm only representing that EB5 investor. If I'm representing EB5AN, I'm only representing EB5AN, doing their securities documentation, litigating for them, XYZ. Now, if I want to represent both sides, say I want to do the project docs for EB5AN, I want to be their marketing person, I want to be their consultant, and I'm getting paid by them. And I also then am doing their EB5 files, and I'm also getting paid by the investor. My loyalty, because of the amount of money that will be paid out by the regional center, is going to be a lot higher, is going to lie with the regional center. What that will do is I will make sure I make the source of funds work, even if I don't think it crosses the threshold, even if I don't think USCIS is going to approve it. My duty and my responsibility is going to be towards EB5AN because they're paying me all this money to make sure that I file this application for the EB5 investor. So it's extremely important that you make sure that the attorney is not in that boat. The bar rules have clearly stated, if you're going to represent both sides of the transaction, you need to get the client to sign a conflict of interest waiver. The problem is the conflict of interest waiver doesn't really say conflict of interest waiver in bold and doesn't really explain what exactly is going on. There's a lot of legalese, and a lot of the real issues are hidden behind that legalese. And clients are always flustered or don't understand, what that means. So clients end up signing that document and not knowing until the fund goes down that this attorney or this firm was representing both sides of the transaction. So it is extremely important that the attorney you pick is your fiduciary, is the one that's looking out for your interest. It is my job to tell you as the investor, hey, this source is not going to be approved by EB5, by USCIS IPO office. Please do not file this application. However, if I'm in bed with a regional center, I'm going to say, this is going to work just fine. Go ahead and file it. And then, of course, you're going to find out 2 to 3 years down the line, this didn't work. And in that case, you'll get an RFE, you'll get annoyed, and then I can just throw my hands up and say, well, we tried. It didn't work. But you've now lost time, you've lost money, and you've lost immigration benefits. So extremely important for you to understand that the attorney should only be representing you in this transaction and not both sides of this transaction. Even if you're referred to this attorney, say by EB5AN or another regional center, this is a question you should be asking in writing over email. My recommendation to clients is when you're communicating with regional centers or attorneys, questions like these need to be asked over email because there's record of what was said. If a regional center or a project or an attorney is unwilling to answer these questions in writing or kind of coerces you to jump on a phone call so that they can answer these questions, that is not enough. That is not good enough. If I am unwilling to say, I'm not in bed with EB5AN or I'm not in bed with another regional center, that is not good enough. That should prevent you from hiring me. But if I can, with confidence, state on an email, yes, I'm independent and I only represent investors, you can be confident that if I have lied, you can come sue me. So very, very important for clients to ask these questions, whether they're abroad or in the United States.
Great. And yes, investment transparency and avoiding conflicts of interest are absolutely critical. And the company, the law firm that we use to prepare all of our project documents, they do not represent individual investors. And so we really, really like to have that independence and transparency so that the attorneys that our investors select, it's completely their choice. Obviously, we recommend attorneys that we get good feedback from clients about their experience. And we often, will introduce multiple attorneys because it's really important for clients to, interview a few different personalities. Sometimes one attorney, you're not just getting the experience and the paperwork, you're also getting the communication style, the languages, the time zone, the bedside manner. There's a lot of different factors that go into selecting an attorney. Anahita is one of the top attorneys that many of our clients do choose to work with, and her work is impeccable. And we hear nothing but good things from all the clients that have chosen her. But she's not the only attorney that we work with, obviously, and every one of our investors is free to choose any attorney they like. We can provide a short list of 5 to 10 attorneys that we've worked with over the last 10 years. And if for whatever reason the clients don't like any of those attorneys, they're absolutely free to go to Google, type in EB5 attorney, talk to 20 people, and pick whichever attorney they like, and we can provide the project documents for the Twin Lakes project or any other project that we're working on, and we're happy, more than happy, to cooperate with any other attorney, share all the materials, and make sure that attorney's up to speed. Great. What else did I want to cover? I think the last question I would have generally is, if you're an investor, considering, doing the EB5 process, what's the timeline look like? Like, is this something that can be done, in a couple weeks, couple months? Obviously you want to avoid the situation where, you get fired from Amazon and you've got to scramble, right? So talk to us a little bit about timing and, what's kind of the right time to start the process, and, how does that kind of overlap with your current status and then with availability of funds? One thing we didn't spend any time on at all is partial filing and things like that. But yeah, talk to us just quickly to wrap up on timing.
Yeah, I think that with the uncertainty in economy, what I'm telling my clients is that it's best to file EB5 ASAP, because that way you have access to, say, line of credits, unsecured loans, home equity line of credits. Once you're laid off or unemployed, none of these lenders are going to lend you money. On an average, a client of mine borrows $400,000 to $450,000 from a U.S. bank in order to fund their EB5, and that is only possible if you are employed. If you're unemployed, those options go away, and then you have to use the fallback of a partial filing. I personally am okay with partial filing only if the investor can show and can determine that they're in the process of investing. What does that mean? So that means if you're liquidating a real estate and you're under contract, but it's going to take 60 to 90 days to get that payment, I can for sure then tell USCIS, here's the real estate, this is how it was acquired, here's the property under contract, the money's going to take 90 days to come, but hey, the investor has $100,000, he's already paid that in, and the rest is going to come in 90 days, and once the rest comes in, we will interfile. Well, at that point, I feel comfortable filing with that $100,000. As an attorney who's very risk averse when it comes to other people's immigration, I want to make sure that I can document in the process of investing, whether it is, sale of real estate, or it's a loan taking some time to come through, it's been pre-approved, or it's RBI remittances in India that are capped at $250,000. Things like those, you can easily do partial filing with, and the government understands why you've done partial filing. Where I'm uncomfortable with partial filing is that the client has no asset to tap into and is going to say, hey, I'm going to make the salary over a period of 3 years or over the next 12 months, and I'm going to put that money in. The other problem you hit in an uncertain economy is what happens if you get laid off and now you haven't stuck to the plan. I get a lot of clients that have the money but don't want to borrow because of the high interest rates. And what I tell them is it's better to always fund it 100% if you can. And then you can always put up that asset for sale and pay it off using the sale funds. What you don't want to do is wait for the sale to be completed, liquidate, and then file the EB5. The more time you spend doing all this, the more people are going to be ahead of you in line. As long as the turnaround times, like I said, for EB5 investors that are in the US, 7 to 14 days, I tend to work with my Amazon clients or my Google clients after work hours, after 5 p.m., so they can provide all the documents. Everything's done electronically, everything's assembled electronically. And for Indian clients, the average time is 4 weeks. I have had clients come to me from other firms that have been waiting for 6 to 8 months that have just been sitting because the attorney asked for document A, they provide document A, then the attorney asks for document B, and day over day over day, you start to lose time. So you really need someone who's flexible and willing to work with you in local time zones. I have occasionally also traveled to India to finish source of funds. So that is also an option that we provide as a firm. Again, in this uncertain environment and with a brand new rural line, what I'm telling my clients is let's file ASAP, let's be first in line so that there are many more people behind us and not ahead of us.
Got it. Got it. Thank you very much, Anahita. That was a long webinar, multiple languages, but I think we covered a ton of really important topics. And yeah, for investors who watch this in the future who are exploring EB5, definitely reach out, talk to Anahita, and she'll be able to very quickly tell you, is EB5 a possibility? What documents would be needed? What the timeline would look like? And just kind of help give you that confidence and perspective on how similar your situation is to others and what can be done and what timeline, how much time it's going to take to make the green card a possibility. So thank you very much. And Anahita has our strongest recommendation as well.